You are
Hey, chat.
unmuted.
We're going to do Karen Reed, whatever's happening, and then we'll get into the Kohberger hearing. It's unclear if this is a verdict.
All right. I appreciate you all getting back here. During the luncheon break, I received word from a court officer that the jury had knocked on the door, indicating that they had a verdict. But before I could even summons everybody into court, shortly thereafter, they knocked again and said they didn't have a verdict.
Oh, God.
So I asked the court officer to tell them to put that verdict slip in an envelope and seal it, and to give it to us. Paul, do you have it? I haven't seen this. It's been sealed. I'm now going to seal it in the legal sense. So this is sealed. No one will have access to it. It will be preserved and made part of this record. I'm going to ask it to be marked for identification with the word jury, Chrissy, just to keep it separate and apart from everything else. So it's marked for ID with the word jury.
Maybe not verdict time, Steph. Oh my God, she just got caught on the mic.
All right. So we do not have a verdict because, as we all know, there is no verdict until it is announced and recorded in open court. So we are still awaiting a verdict. Because it took a while to pull this together, I would ask that everybody remain in the building until the end of the day. So
yeah, I mean, they might go back in and come right back out. Ooh, that was a tease. Does anyone feel like verdict blue-balled right there? Oh my goodness. So we'll update this banner. Guys, this stream, when I created this stream for the Brian Kohberger hearing that's about to start in 4 minutes, I was like, there's going to be something happening with the Karen Reed verdict. I just know it. And lo and behold, right before the Brian Kohberger hearing's about to start, we have this. Could this case be any messier? We have a verdict. Wait, no, we don't. After a day full of confusion about jury instructions. And from my reading of the tea leaves, it seems like the jury was pretty set, unanimous on this. We're stuck on this one thing. What happens if we are hung on this one thing? And they've been deliberating all rest of yesterday and then this morning. And then they're like, almost, but not quite just yet. So we're going to get into the Kohberger hearing. We will flip over with any activity for Karen Reed. So this will be half a Karen Reed verdict watch stream and the Kohberger hearing. Let's get the Kohberger hearing up. I had it ready to go, and I think I used it to get over to this Karen Reed fan. Always good to see the fan. So let's get this fixed up. And now with the Kohberger hearing, you guys, so trial was set to start in August. But in May, the defense filed a motion. All of the filings about this motion, the state's response and the defense's response to their opposition, are linked in the description. The main motion is pinned, I think, it should be, as a comment in the chat. If you want to take a look at it, the initial motion was 40 pages. In short, the defense is motioning for a continuance. They want to delay the trial on the grounds that, there's too much media attention still, probably in response to an NBC Dateline interview that rolled out a few months ago. And some of this media coverage, including this Dateline episode, included information that wasn't disclosed to the defense. So it's not just, hey, media buzz, we need more time to prepare for trial. There's also that media buzz included information that wasn't disclosed to the defense. The media had to obtain that information somehow. So was there possibly a delay in the discovery that should have been turned over to the defense? So the judge is going to hear arguments on that today. Besides that motion, they're also going to do a status check. Is all the other discovery looking good? Are we ready to proceed to trial if this motion isn't granted? So that's what we're going to be getting into today. Let's see. There's a few channels doing the stream that I've never used for a stream before. So we'll put this one up for now, but try to poke around for one that has closed captions for you guys. Fox 13, no closed captions from them. Law and Crime's gonna air it, so I'll keep Law and Crime up. Law and Crime is like 80% of the time they have closed captions, you guys. So as soon as that feed starts, we will look. We will look. Shout out to everyone for coming to hang out. If you guys want to take a a straw poll in the chat, what do you think the verdict's gonna be in Karen Read? Obviously, you got to kind of spell it out, right? There's the different counts. So if you think it's going to be split, you got to do a little bit more writing than guilty versus not guilty. But just a quick informal poll would be awesome. Guy Vermectin, good to see you. Says it needs to happen, but it won't. I believe this is in reference to the motion to, well, actually, depending on how you read this, it needs to happen. Do you want the trial to happen, or do you want the motion to delay the trial to be granted? Guy Vermectin also says there's a book coming out by a pretty famous author right before jury selection too. Oof. Yeah, that's not good. That's, you know, something that makes like the New York Times bestseller list. Hard to say that that wouldn't potentially reach the jury pool, right? And guys, for some context, a while back, the defense made a motion for a change of venue, and the previous judge granted the change of venue. So this case moved from Latah County to Ada County, right? So we had a change of venue already. And now things like this, could the jury pool be tainted all over again? So, hot mess, hot mess. FFS, boop to you. JC from the D, thank you for writing the chat before we went live. This was how I realized that there was commotion in the Karen Read trial. So big thank you for the relay. Miss Lele, good to see you. Juanita, long time. Good to see you on a live. YSL Tara says, FFS Bev, really? You know, that one might not have been Bev's fault in this moment, but the way she handled the jury's questions yesterday seems like that could have precipitated why we have you know that meme of, I think it's Winslow, the mouse from the show Cat Dog, and he like walks out the door and then he walks right back in the door. I think what Bev did yesterday precipitated what we have going on with the jury today. But yeah, that uncertainty seems like something called reasonable doubt. Candace, so yeah, Plans and Pens was here yesterday talking about the Atlanta dad, the starvation trial, where a young girl was starved. She died. And the dad's on trial. And Candace is pointing out, you gotta watch the verdict about that trial. So guys, that's another one to keep an eye on. I believe it was Atlanta News First or 11 Alive that was streaming that. I only got to caught a bit of the prosecutor's closing arguments. So I don't know much more context, but a lot of people have said that that's a crazy case. Go check it out. Danielle Judge says, so who intimidated to make them change their minds? I don't know. Wasn't there like, you know, this is speculation territory, but wasn't there rumblings yesterday? I want to make sure I'm real time here. This is like 5 seconds behind. There was some speculation with juror issues in trial 1 for Karen Read. You know, and Bev never really got it on the record. You know, a juror has the right. As citizens, we have the right, unless there's a reason not to. You know, maybe we have a felony conviction that excludes us, or we're voir dired out. But as citizens, we have a right to sit on a jury. Right? It's not just the defendant's right to have a fair and impartial jury. It's also our rights. Our right as citizens to sit on a jury with certain exceptions excluded, right? But in trial 1, there was, somebody saw one of the jurors at an American Legion, and, you know, they were eating, having beverages or whatever, and a news blip was up on the TV about the trial, and it seems like they were talking about the case. And Beverly took the word of a hearsay to one of the bailiffs in the court took them at their word, didn't even really question the juror to find out and get that foundation laid that, yes, the juror was actually speaking about the case outside of court. Just let the juror go. And I thought that was despicable. You know, if you question the juror and you get a solid answer, yes, I was, you know, doing something I shouldn't have been doing, then dismiss the juror. But without establishing that, I'm not sure that that person, that juror, gave up their right to sit on the jury. So, speaking of, you know, did somebody say something to make them turn around? I think it's probably just an uncertainty issue because the forum is a mess. Do you guys want to look at the new verdict form? I don't think it's all that better than the original. So let's look at the jury form that was released today while we're waiting for Kohberger anyway. Shout out to Factual Lie, who says, you feel like you're parked diagonally in a parallel universe. You know what? This change on the verdict form, they did fix the alignment, so maybe you'll feel like you're parked straight after we look at this new verdict form. Let's see, we've got... Alrighty. And I've got my earphones in, so I'll hear if court starts. Make this bigger. All right, it's a little blurry when I'm zooming in, so sorry about that. Yeah, this verdict slip in the original verdict form was like over here. It was not aligned very well. But they added in... Oh, let's go to the next page, which I guess is the page of interest. Let me open the second page. When I said I was reading tea leaves, and I think a lot of people were reading the same tea leaves, you know, one of the jury's questions yesterday was about, you know, if we were to be hung on 5, would she be found guilty of, back to page 1, of manslaughter? Because the way this works, there's 5 line items. Line item 1 is not guilty of anything. Just none of it. 2 would be guilty of the offenses charged, but then 3, 4, and 5 are guilty of lesser included offenses. So 3, 4, and 5 are things that are introduced as lessers for the manslaughter charge. But the way they're aligned, it's a bit confusing. I can see why it confuses the jury. So the jury asked this question yesterday, well, you know, if we were to be hung on this, it seems like a juror or jurors are predicting that Karen could face trial again for a manslaughter charge, not just OUI. So, chat, if you were looking at this form, can you relate to why a jury might think they had it down and then they were like, oh no, wait a minute, we're not actually sure, let us look at it again? And I don't know what that sealed verdict slip says, but I would be very disheartened to find out if that sealed verdict is a full acquittal and then they have doubts and go back in and get hung or decide that they want to actually convict of maybe a lesser included offense. I think that's so unjust. I just think that that's unjust. Because it sounds, if you were unsure, but you were sure enough to agree to an acquittal, and that's what's in that signed packet, sounds like reasonable doubt. Now, if that packet contains, you know, they're hung on something, or maybe they said, yeah, we're going to find her guilty of this lesser included, and then they said, well, wait, we're not actually sure. I think that's someone addressing their doubts, right? So we won't know. We won't know what's in that packet. But it's just so much food for thought. I mean, imagine your life is on, your freedom is on the line. This is your second trial, and the jury has questions about how to use the verdict form. The piece of paper is causing more or just as much of an issue as the issue of fact in the trial. Like, that's just twisted. Yes, Danielle Judge. It was the deputy. I don't know why I always say the word bailiff. But, yep, so there was a deputy that was watching the jury in the first trial and, had a relay whisper to the judge that, we got wind that a juror could have been talking about the case. So, let's see. Mr. Big Play Bray says who's going to play Karen in the movie. We'll open this back up. It also looks like Law and Crime hasn't even started their feed. So we'll keep this feed up from the courthouse itself since it's already running live. I think that'll be our first signal when the Kohberger hearing starts. JC from the D, let's talk about predictions for Karen Reed. Not guilty on the first, second, and third charge, guilty on the lesser of OUI. And what an L that would be, right? A small shout out to Adam Lally, right? Because you have this big budget special prosecutor, Hank Brennan, come in over here.
Proceeded.
And he didn't do any better than Lally. So, new courtroom here, you guys. Got some members of the public. We have a verdict. I knew it. Chat, we're going to start this fresh. They'll probably do some paperwork anyway. Karen Reed action as soon as the thing is scheduled, and now as soon as it actually starts. Look at that. So here we go. We're back to the fan. We will get caught up on Kohberger. But I'm pretty sure if we were to do a chat vote, I think the majority would be okay with doing the verdict and then flipping over. So, and it should be quick factual lie because first of all, I don't think anyone had time to leave, but Bev did say don't leave. So, all right, final votes in, you guys. Final votes. Do you think full acquittal or not? Mr. Big Play Bray with the popcorn. Just crazy. Yeah, David Trailer, if you just got here, there wasn't a verdict, and now there is, apparently. So, we're here, you guys. What do you think Bev's next case will be? And yeah, I see over on X, everybody. Lots of pandemonium about this. Oh, that's crazy. Cash Money Cass tweeted about 227. We almost had a 227 verdict. That would have been hilarious. You know what? They did their verdict and then they deleted it. They did their verdict at 227 and they deleted it, chat. Just to make it a familiar joke. Yeah, Sapphire Ridge News, good to see you, is saying retirement for Bev. I think a lot of people are rooting for that. David Trailer's going to find a way to mistrial. Can you imagine an acquittal and Hank wants to poll the jury? Oh my goodness. All right, so relayed from factual lie. We'll say Bukake just walked into the back door of the courthouse, phrasing factual lie with Brennan. Phrasing two times. Shout out to Nicole, good to see you. Yeah, Danielle's thinking guilty DUI, not guilty everything else. Auntie Bev better think about retirement. This is true, Tara. So yesterday, you guys, I thought yesterday was Wednesday, so I thought court was closed today. But court is closed tomorrow, Thursday, actual Thursday, for Juneteenth. So that's going to be, you know, federal holiday celebration time. If they didn't have a verdict today, they would have had to come back Friday. So, no, factual lie, don't apologize. That was hilarious. Like, I caught the bukkake, but the entered through the back door got me there. Lady Libra, good to see you. Hello, right back to you. Shayna, so if you guys are tuning in now, there was almost a verdict, and then they said, oh, wait, no, we're not ready. So, bailiff relayed to Bev. Bev sealed the verdict form that they had at that time and wrote jury on it to preserve it for the record. They went back to continue deliberations, and they came back out, so... I don't know, maybe it's something like they want to write, like, not guilty next to manslaughter, just to reiterate. You know? Yeah, tape is the moment we've all been waiting for. Between this and Kohberger, we're going to be going back and forth between two moments. Oh, have a good one, David. Right, it's right at this moment. You get busy, right? Yes, Shayna, an almost verdict. An okey doke verdict, if you will. An old switcheroo. Just a whole time with this trial. Guys, if you are tuning in late, what we're going to be looking at with the Brian Kohberger hearing is it's a status conference. Are we ready to proceed to trial? Are all the discovery, everything sorted out? Everybody has what they need. But in addition to that status check, there was a motion filed in May that hasn't been heard yet. The state has responded, and the defense has responded to that opposition. Defense is requesting to delay the trial. So there's been a lot of media coverage. Some of that media coverage has included stuff that wasn't turned over in discovery to the defense, but the media had to learn of it somehow through an agent of the state, right? So police officer, detectives, maybe prosecution had it. One way or another, the media got their hands on something that wasn't disclosed to the defense. So the judge is going to hear arguments on that as well, and that will obviously impact, if the judge grants that motion, that's obviously going to impact our status, right? We're probably not going to continue with our trial date. So there's that. And I haven't really seen, those motions are linked in the description, you guys, if you want to read them. I didn't really see anything else interesting in recent filings. With the Kohberger case, so much is being filed under seal. So a lot of the recent updates on the docket are just, hey, we're filing something under seal, and you don't really get much context about what it is. There is a link in the description with the link to all of the Kohberger case files. So if you want to check that out, you can do that. But again, it's going to be a swath of just under seal, under seal, under seal. But shout out to the courthouse for making those documents available. It's the same courthouse as one of the Lori Vallow cases, and they've made the Lori Vallow documents available as well through their high-profile case files. So if you're into the Vallow case, there's tons of documents on that same link that's in the description. You just have to go back and find Lori's case. Yeah, destined to be, good to see us, as this verdict is on par with this whole trial. And Tape is TV. Oh, Tay-Biz is giving us 10 almost verdicts in the chat, you guys. So if you just turned green, make sure you're saying thank you to Tay-Biz. That is super generous of him to do, especially keeping us occupied while we wait. I mean, there could be a chance that they okey doke us again, right? Hopefully they don't. Which is holy moly. Holy moly. So big shout out to Tay-Biz. You guys already know the drill. Tay-Biz, one of my favorite people to listen to when he looks at cases. He sprinkles in the right amount of humor and positivity while being respectful of tough topics. So I think you'll love it over there. Make sure you check him out. His link is in the chat, or just search Tay-Biz TV. Thank him again if you turned green. Okay, Ah, Lady Libra. I knew your picture was familiar. Guys, so Lady Libra, aka 403 Ready. There we go. So now you have an AKA, or formerly known as, you could be FKA. But the picture was familiar. The picture was familiar. Tony Robinson, good to see you. Good to see you. And guys, we are hanging out for this Karen Read verdict. It should be pretty quick since everyone's supposed to be, I think. Let's see what Kathy says. I don't know. Kathy doesn't have an update. So we'll wait and see. We'll get caught up on Kohberger. All right. Turtle Boy is saying, and this is in reverse order. So the most recent from Turtle Boy is Alan Jackson is pacing around by himself, cheeks puffing in and out. He's deep in thought. Never seen him like this. They have shut down the entire street outside. I can see out the window. The entire sidewalk and stairs of the registry are packed with people in pink. Cops are everywhere. Helicopters can be heard overhead. We have been waiting for this moment for 2.5 years. Karen Read looks extremely strong and brave right now. She is trying to hold it together, clearly fighting back tears. Her lawyers are all hugging her and each other. Bob Alessi is telling jokes to lighten the mood. They are all laughing. Karen Read is giving huge hugs to her team of interns. Her lawyers are all hugging her parents. This is extremely emotional. There are thousands of people standing outside in anticipation. Oh yeah, this is the copy paste. Bukake just walked into the back door of the courthouse. There we go. And they said it's going to be about 10 to 20 minutes, 9 minutes ago. So it could be any minute. So somebody left. Somebody left the courtroom and needed to be present, it seems like. Hey, Shannon. Hey, Shannon. Let's see. And then Kathy. All right, Kathy just did the breaking. Verdict has been reached. So, and she says, look at the parentheticals. For real this time. And they stopped the clock. The clock is stopped, chat. Let's make sure we're all the way forward. It's time. It's time. Yeah, you know, were we that nervous for the YSL case? I mean, I think so, because remember that one question about the lyrics. Guys, this is why, you know, as obvious and apparent as the jury's questions seem to point to in the Karen Read trial, that they're acquitted on murder, right? They're not going to convict Karen Read of murder. They seemingly don't want to convict on manslaughter, but they don't know what to do about this OUI lesser included, right? I'm still reading tea leaves looking at that. And you never know. In the YSL trial, the jury asked a question about lyrics, and the lyrics could have signaled that they thought the lyrics were related to what crime was accused, shooting at the ops. Then we find out from the jurors after the trial, there was just a juror with a language barrier who just wanted to make sure, like, listen to the words again. That was it. It wasn't like all 12 jurors were like, the lyrics are damning. The lyrics are obviously about a specific crime. But that question caused a lot of panic. It shook a lot of nerves. So, and it happens. It's an adrenaline moment. I mean, and yes, Mr. Big Play Bray, the verdict in YSL, guys, if you did not watch that trial or you didn't catch the verdict live, super fast. You know, this was a RICO charge. There were 2 remaining defendants. Each of them had several charges each. And Judge Paige Whitaker was just like, all right, so Diamante Kendrick, you're not guilty on all counts. And Shannon Stillwell, you're guilty on possession of a firearm by a convicted felon and not guilty on everything else. Like, that's kind of how she read the verdict. She just sped through it. So, I enjoyed that. I actually enjoyed the way that verdict was read. It was a subtle judicial FU to the prosecution, that took like 2.5, 3 years to bring this case forward, largely centered on things that happened in 2015. For what? For what? Yeah. Hey, Asia. Good to see you. Yeah. Terry, yeah. Paige flew right through that. Right through it. Yeah, and Tay Biz, I mean, that's why, like, the question about the lyrics kind of got under my skin. It wasn't just about the case at hand. It was also like, oh my gosh, are jurors really relying on lyrics? And I agree, using music lyrics as evidence is unconstitutional in the first place. I would be okay with an exception where it's particularized, it's specific. But if I'm talking about riding around the block, shooting at my ops, that's just character evidence, unless it's like, on that rainy Thursday last month, I went by this blue house with the weird characteristic thing, and like there's got to be some specificity there. And there was a case where a musician did write a song that was pretty specific, and he ended up being convicted. But his lyrics like told the bullet points of the story. And I think that's an okay exception. But this idea of looking at social media pictures and lyrics and then trying to build a case from that just isn't the right way to do it. Yep. So, Lil Durk, YNW Melly. And it's weird because right when YNW Melly was arrested, I don't see him in here, but Biko, if you pop in today at all, it's been a while, Biko relayed to me on X. There was someone on Twitter, another rapper, and again, it could have just been him trying to get clout off, a major news story. But he was posting pictures on his X of the chain that the deceased was wearing, acting like he was the one that actually did the shooting. And the defense attorneys tried to get this evidence introduced as a possible third-party culprit. They wanted to call this guy as a witness, and it was denied. They weren't allowed to. So it's like some guy wrote a song, posting on X, social media, these things that we hear detectives love, but because it would have hurt their case against Melly, it would have been something that could have led them down a different path to finding a suspect, they didn't even want to look into it. And I just thought that was weird. Angela, good to see you. Yeah, Steph J cases outside the courthouse looks crazy. I would imagine, I'm not sure, but I would imagine, shout out to Justice Served TV. I would imagine they're showing, they've had a lot of coverage where they go around and talk to people. Every time the camera bounces, I think they're going to pan and get us here to the action. Yeah, Papa John. How will Auntie Bev make this about herself? She could learn a lot from yesterday's judge, just saying. The Megan Jackson judge, that judge was great. That judge was great. Sincere, sharp. Didn't want to let anybody run on when he already knew what he needed to know. Wasn't going to let some BS in his court. Made sure the jurors always had their own notepads. And guys, this is... Okay, I don't see them. They're not actually outside the courtroom. I feel like if I were to switch to something to show outside the courtroom, they would start with the verdict. That's just how things go. Let's see. Shannon says we all need to play ourselves for the movie. Heck yeah, the people matter. And I'm not trying to insinuate that people are looking to the court of public opinion for anything nefarious, but I do think the court of public opinion, it's not just can it taint the jury pool. We had attorneys during the YSL trial going and visiting different chats, or their teams would go and visit different YouTube chats and look at the feedback, look at what you guys were saying. How are normal people, average people, reacting to the evidence being presented or the witness that's currently on the stand? How are they reacting? And if they're reacting one way or another, do we need to address that? Do we need to call a witness, right? Because remember, the defense, when it was just Doug Weinstein and Max Shart, they opted not to put on a case in chief, right? Here we go, guys.
You are unmuted.
We got the court cough right away. I'm a little nervous.
Will the deliberating jurors remain standing? Defendant remains standing. All other parties may be seated.
Your Honor, may the record reflect that 12 deliberating jurors and 6 alternates are present.
Yes.
May I inquire?
Yes.
Mr. Foreman, members of the jury, have you agreed upon a verdict?
Yes.
Thank you. May I see the papers? Mr. Foreman, have the verdicts that have been placed in this envelope and have they been in your presence ever since?
Yes.
Mr. Foreman, on docket number 2282CR117001, murder in the second degree, what say you? Is the defendant at the bar guilty or not guilty?
Not guilty.
Not
So say you,
guilty.
Mr. Foreman? So say you? No. Do you agree?
Yes.
Do all of you agree? Yes. Thank you. 002, what say you? Is the defendant at the bar not guilty or guilty?
Not guilty.
Of.
Bev.
Is not guilty or guilty of that charge or any lesser included charge? Thank you. Specifically, number 5, operating under the influence of
They
liquor
got her.
by operating a motor vehicle with a blood alcohol level of
They gave her the
0.08 or
OUI.
greater. Correct?
Yes.
So say you, Mr. Foreman?
Guilty.
So say you all?
They got her on OUI.
003, what say you? Is the defendant at the bar leaving the scene after accident resulting in death? Is the defendant not guilty or guilty?
Not guilty.
So say you, Mr. Foreman?
You
So
hear
say
the
you
crowd?
all? Jurors, hearken your verdict as the court records that you, upon your oath, say the defendant on 001 is not guilty, on 002 is guilty of operating under the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be seated. Jurors, we thank you for your service. We're going to send you back. Your service is complete. I'd like to come back and talk to you for a little bit afterwards. So thank you very much.
All rise. Jurors, follow me.
Aw. You hear the free Karen Reed?
Media, please exit the courtroom immediately.
Karen Reed?
Not
Not yet.
Tony,
Hold on,
not yet.
hold on,
Not
everyone.
yet.
Karen Reed. Ms. Reed, can I have your attention? As required by statute, I must inform you that the records regarding the charges that you have been found not guilty will be sealed by the Commissioner of Probation by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want these records sealed. To request that these records not be sealed, you may use the Request Not to Seal form, which is posted on the trial court's website on mass.gov. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. Please be aware that if the records regarding the charges which you have been found not guilty are sealed, you will be unable to access the sealed record of the not guilty dispositions or any other records regarding those charges. If you want copies of any documents regarding those charges before the records are sealed, you should request copies from the court within 10 days. Do you understand? Thank you.
All right, so we need a date for sentencing. Can we do it next week?
Bev.
And we would be prepared to go forward today.
Okay. Okay.
Oh boy. I was like, okay, whatever. We need to sentence her. What a beautiful thing to hear the public outside. We didn't hear them interfering during trial, right? They behaved during trial. They didn't violate that while trial was ongoing. But as soon as that verdict's in, they went bananas.
All right, so Ms. Giannetti, you're ready to go forward today as well?
Yes, please.
Okay, Mr. Brennan, what's the Commonwealth's
Up to
recommendation?
2.5.
The Commonwealth moves for sentencing. We recommend a probation, 1 year, 24D program.
So the standard that everybody else
No
gets
jail.
on a first-time OUI?
Certainly.
Bev is disappointed.
So I'm happy to do it. All right, thank you all.
1 year
1 year
probation or 24 months?
1 year probation on docket number 002, the lesser included offense of operating under the influence. 1 year probation. Thank you. The 24D program is.
24D. 1 year probation is crazy.
Goodbye.
How the lengths they went through for this trial. Beautiful. And I am so glad Hank didn't just be an ass for the sake of it. Same as everybody. So Hank laid down his sword a little too late, but Hank laid down his sword. Aw, look at the audience. So, and that's the thing. I agree. I don't think John O'Keefe was hit by a vehicle. I think it's much more reasonable to think that he fell and hit the back of his head. And this woman, granted, she has been out on bail. She has not been in custody. But this still consumes your life going through this. She's selling her assets. Her attorneys were working for free. They still had to pay experts. They were fundraising to pay experts. Like, just because she got a not guilty doesn't mean that on the top charges, and she's only got to do probation, I still feel like she gave the state time. 2.5 years plus. So this is, yeah, thank you guys for watching this and being, you know, malleable to switching as things are happening in these different trials when different things are going on at once. We'll watch the exit and then we'll get over to Kohberger. What a day. What a day. Aw. Oh, and the interviews are going to be so good. You know, if the defense team does any, if Karen does interview, I mean, she's already been comfortable doing interviews. So if I was Karen, I would be on, let me make my money back. Let's do some interviews. Let's talk about this. Oh, goodness. The jurors, I hope the jurors want to speak. There we go. One more fan. One more fan. All right, so we'll put some updates in the chat as things continue, if anything interesting is said, but we're going to go over to Kohberger. There's some background on the Kohberger case in the description. There's also the documents about the motion to delay the trial, all linked in the description. Oh, we're outside. Wow. Holy moly. All right. Incredible. So guys, that is, if you guys want to continue watching that, I'm going to drop the link to Law and Crime stream. If you guys want to see the crowd, what a powerful, powerful thing. the public is speaking. The public is speaking. With Brian Kohberger, again, he has not had his trial. And it could be an issue possibly where media possibly tainting the jury pool. Is that going to be an issue? We're going to see what this judge thinks. Judge in the previous county, Latah County, granted the defense's request for a change of venue months ago. This is now Ada County. But there's still some issues with things that are getting out into the media that have not been disclosed to the defense. So we're going to go through those motions, and we're going to have a general status checkup and see if trial is going to continue on the day it was set for. I don't see closed captions. I will look for closed captions.
All right, this is CR 0124316665, State v. Kohberger. On behalf of the state, we have Mr. Thompson and Mr. Horwitz. And on behalf of, when this, should note the defendant is present with counsel, Ms. Taylor, Ms. Massoth, and Ms. Barlow. This is the time set for, or at least the public portion of today's hearing is set for the motion to continue the trial filed by the defense. So we'll start with that.
Good afternoon, Your Honor. Your Honor, our motion to continue has been filed and is necessary to protect Brian Kohberger's rights under the United States Constitution and the Constitution of the State of Idaho. Specifically, a continuance is necessary to protect his due process rights, his rights to a fair trial, his rights to effective assistance of counsel, rights to confrontation, Mr. Kohberger's right to present a full defense, and if it should come to it, a fair sentencing hearing and to be free of cruel and unusual punishment. The record of this case spans 2.5 years, and it shows that this request does not come as a surprise. Looking through the history of this case shows that the defense has met challenges and difficulties along the way, but has been dedicated in meeting all of the deadlines. We have talked about the discovery issues in this courtroom before, and that in large part brings us to need a continuance. 68 terabytes of information is a huge amount of information.
Wow.
There have been 23 requests for additional discovery over the span of 2.5 years and 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I would direct the court to look back to May of 2023 and June of 2023, and our second motion to compel. Included in that was what was known as Exhibit A from the defense, and that depicted how we were receiving discovery. So this is not a new issue. This is something that's been coming up for a long time. We were receiving discovery, but it was such that you would get a file that would say hundreds of photographs, hundreds of pages of reports, each having to be looked at individually to know what was there and then organized. This case has also faced unique issues, starting with the media coverage of this high-profile case, non-dissemination orders that were addressed in courts, and then the grand jury materials that we had to fight to get access to before we could properly challenge the grand jury indictment. We faced issues with discovery, particularly with the IGG materials. We spent a great deal of time trying to get access to those materials. Those were ultimately, what we could get was ultimately presented in a motion to suppress, and that's preserved should there be a conviction in this case. We faced venue issues in this case, culminating in the change of venue and bringing us to Ada County. At the first hearing in this courtroom, we discussed the discovery issues and not having read everything and being ready with a full investigation in this case. That was apparent through our motions to strike the death penalty, our motions to compel expert disclosures filed in September and December of 2024, and requests for more time to file our motions in limine that was granted in January of 2025. Throughout the course of the motions in limine and then a motion to strike death based on discovery issues in February and March of this year, the record is replete with notice that we are not prepared to go to trial in this case. The discovery is vast and we have not had a chance to review it all. That we met deadlines for experts shows our dedication to comply with court orders. It does not depict effective counsel ready to go to trial on this case. we would submit that it's the court's responsibility to assess this motion to continue with heightened due process that's required in death penalty cases. The death penalty case is different. That comes from Ford versus Wainwright at 477 U.S. 399 at 411. The court must be sensitive to safeguard every avenue of due process. The Idaho Supreme Court said the qualitative difference between death and other penalties calls for a greater degree of reliability when death is imposed, and that comes from State versus Creech, 105 Idaho, 362 at 383. Looking at all of the constitutional rights Mr. Kohberger has, effective assistance of counsel really becomes the crux of how all of these other rights are covered for Mr. Kohberger. And effective assistance of counsel applies both to the merits phase and the penalty phase of a death penalty case. The courts are guided and counsel is guided by the American Bar Association guidelines on capital cases. Wiggins versus Smith, 539 U.S. 510 at 524, said the ABA guidelines are guides to determine what is reasonable. And that's talking about reasonable performance by defense counsel in a capital case. The Ninth Circuit in Andrews versus Davis at 944 F3D 1092 at 1109 relies on the ABA guidelines as the proper measure to test an attorney's investigation. In Idaho, our public defender statutes reference the ABA guidelines as applying to indigent defense. These apply to the full investigation of the merits phase and require us to raise all legal claims. They require us to perform a background on all witnesses that might be called, especially those being called by the state. That means that we have to review all discovery to be able to present a full defense for Mr. Kohberger. We cannot present what we are not aware of. I would note for the court that discovery has been ongoing. I received discovery just this week. It is discovery that I have not reviewed yet. Considering what's required at a penalty phase in a capital case, we're required to perform in a way that the jury can carry out their function of individualized sentencing. That means that Mr. Kohberger's background has to be known and investigated and ready to present to the jurors. Evidence of his character has to be known and ready to present to the jurors, and his circumstances have to be known and ready to present to the jurors. That's addressed in the Woodson case and in the Lockett case. The jury must have the opportunity to consider all evidence that may weigh against the death penalty, and that means anything from his life history. It is the duty of the defense to find and investigate all mitigating information.
So guys, just a quick reminder, with a capital case, there's the guilt phase and the penalty phase. So with a capital murder, the jury will also, it's almost like a miniature trial that will take place where the prosecution gets to present aggravating factors and the defense gets to present mitigating factors. Can this individual be rehabilitated? Would it serve them to keep them alive as a possibly contributing member of society? These different things will be presented as sort of a mini trial after and if Kohberger is found guilty during the guilt phase. So she's describing that this is interfering with their ability to do this research now. And once trial starts and you're in trial every day, it would be very difficult for any counsel to competently put together the information they need to present during the sentencing phase when necessary. So this is important to have before the trial starts.
We do have several experts that would be ready for the mitigation portion of the case should the case reach that phase. And they rely on understanding family history and Mr. Kohberger's own history. They can only understand what they've been presented. And the investigation to fully evaluate needs to be thorough. That means that records have to be collected. That means that interviews, collateral Collateral interviews have to be done, and those have not all been completed. And it's not because of a lack of diligence in this case. Further, when things that are noted as red flags arise, those things must be investigated. Red flags aren't fanciful ideas of what else could we do in this case. They're real things that come up in the course of the investigation, and whether or not they're important to mitigation and presentation for a jury's consideration requires time to investigate and collect records. Documentation is very important. The court's aware that red flags have come up and they require further investigation. Those are issues that may mean a lot to the experts that would be ready to testify, but they can't be presented until there's a full investigation. They are things that might change the course of the evaluation or might require us to have an additional expert to help explain certain circumstances. And that's important for the individualized sentencing that's required by the Constitution. Your Honor, there have been numerous challenges with gathering records and interviewing collateral witnesses. I know the court is aware of some of those particular issues. I'm not going to highlight them now, but it's imperative that we be able to collect records and conduct interviews from other family members besides just Mr. Kohberger and his parents. And it's also imperative that his history be complete with educational records, medical records, and those things are still being done to this day. The other reason that a continuance is appropriate in this case is based on the media coverage, the Dateline issue that has been talked about in this courtroom before, and what's yet to come. The Dateline episode wasn't just a one-time deal back in May. That continues to be talked about. Everything that happens in this case continues to be talked about, and this court has a duty, a responsibility to make sure that Mr. Kohberger receives a fair trial. That comes from Shepard versus Maxwell, 384 U.S. 333. And a continuance may be the way that the court can best protect Mr. Kohberger. That comes from Patton versus Yount, 467 U.S. 1025. In addition to what is going on with what happened with the Dateline episode, that's not all. There's a book set to be released just a few weeks from now to be followed by a docuseries on Amazon Prime. There's a claim that there's inside sources that provide information in this case. At the very least, the moment we start attempting to select a jury in this case, those things are going to be on everybody's TV, everybody's social media feed, and some of the very witnesses that will be expected to testify will be taking part in the docuseries at least, and maybe noted in the book. That is, in and of itself, an exceptional reason for us to have a continuance to let those things play out for a while. I would also note, Your Honor, that jury selection is going to be particularly challenged and will need a great deal of time based on what's happened in the media and continues to happen. Your Honor, our request is for a continuance in this matter to allow us to be effective and perform our constitutional duty for Mr. Kohberger, to protect his constitutional rights, to make sure that we have fully investigated all mitigating circumstances so the jury, if it comes to it, can perform their individualized sentencing, judgment, and function, and to allow some space between what's recently happened in the media. Thank you.
Prosecution's opposition.
May I, Your Honor?
Of course.
Thank you, Your Honor. I will, I think, address Ms. Taylor's arguments sort of in the reverse order in which she raised the issues that she raised. I want to begin, though, by bringing us and the court back to what the standard is for this motion to continue as opposed to what might happen after a conviction with respect to ineffective assistance of counsel. Right now, the standard is whether denying a continuance would violate the defendant's rights by causing unfair prejudice. And that is an objective standard that the court has, and the court has discretion on all motions to continue, including a motion to continue in a case such as this that involves the death penalty. What the defendant and counsel are asking the court to do is delay this trial because of their subjective, prospective beliefs about how an ineffective assistance of counsel evaluation would happen by an appeals court if there is a conviction. What this court should do is use its discretion and look at the objective record. The record supports denying the motion based on what the defense has been doing, continues to do, and will continue to do through the mitigation phase until the penalty phase, including presenting mitigation evidence that the jury will ultimately decide about if there is a conviction. The lens that the court should look at is well stated, through which the court should look at this motion is well stated in some Idaho case law and others. And if I can turn on the Elmo, do I need to hit this button, Your Honor?
And Clark needs to switch it over.
Okay, thank you.
Fumble, technology.
So these are cases that we cited in our brief, and I wanted to start my discussion with them. I'll read the top case, which is an Idaho Supreme Court case, evaluating whether counsel was effective in a death penalty case. Counsel was not required to investigate defendant's entire life in order to objectively and reasonably present mitigation evidence. And then I like the way that the Seventh Circuit sort of rephrased the same principle by saying, I won't read the entire quote, Your Honor, but a scorch the earth strategy is not required. We're in a standard of reasonableness. And the record that is before the court, and I'll acknowledge we have not seen what specifics, if any,
Sorry, Chad.
the defense has put forward in its ex parte filing.
It's kind of hard for you, I recognize.
It does, but we have not seen specifics. I did not hear any specifics from counsel just now about these witnesses need to be contacted, these records need to be obtained. And then the court, I think, mentioned at prior hearing we had when this was motion to continue was first raised, that the court would be looking at what admissible evidence the defense needs to obtain and what strategies would actually be used to fruitfully obtain that evidence. And we don't have anything specific that we can respond to about that. So I'm at a bit of a disadvantage, Your Honor, but I think the record that we do have shows that the court can use its discretion to deny this motion to continue. What we did in our response brief, Your Honor, was to cite the fact that the defense has identified 55 defense witnesses for mitigation, and I think one was recently added, so we're up to 56, 132 exhibits to use at the mitigation phase. And with respect to the ABA standards, we're not saying the court should completely ignore them, but what we are saying is that the court should look at them for what they are, which is a retrospective tool for appellate courts to look at the performance of counsel after a conviction, not some checklist that needs to be religiously adhered to in order to actually get to trial. Even if the court were to rely on them heavily, though, the charts that we've put together show that for each of the ABA guidelines categories that the defense has raised, we have seen evidence in the record that shows that they had witnesses to talk about those issues and they had discovery on those issues themselves. Now, defense has called that superficial, but we would ask the court to look at the tables and look at the witnesses that we've been able to identify for each category and also the discovery in the record. So, Your Honor, again, we think that given legal standards here on a motion to continue, given the court's discretion, given that we are in a world where the court needs to satisfy itself that defense has done a reasonable job to prepare for trial, excuse me, to prepare for trial, there is no basis for a motion to continue. Now let me turn to some of the specific arguments, and I can take this down, Your Honor, that Ms. Taylor raised. With respect to the media coverage, we acknowledge, as the court has, that will pose challenges for jury selection. The issue, though, is not whether there is a lot of publicity. We know there's going to be a lot of publicity regardless of when this trial happens. As Ms. Taylor said, people will continue to talk about this case. The issue is whether the court, using the procedures it has established, or maybe even modifying them as the court wants to, can seat a panel of impartial jurors. The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case, despite the challenges. The other thing I would mention with respect to the publicity is that it puts us at the whim of the media. Every time there's a breaking story, every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be the danger in what the defense is asking for. We call it a perpetual continuance, and we haven't seen a proposal about when this trial could take place. If there's a continuance, what seems to be the strategy here is just to delay. And that leads me to, I think, the other point that Ms. Taylor raised, which was to say that, this shouldn't be a surprise. It is a surprise to us that a motion to continue was made so late in the game, after, by the way, the trial date was used to oppose an extension that we filed for with respect to our mental health expert. At that point, the defense said we can't possibly go down this road or give the government the state what it wants because of the trial date. Once that issue is resolved, then we get a motion to continue. So I think what we have seen from the defense is that they tried to use the mass amount of discovery to remove the death penalty from the table. When that failed, now we have a motion to continue. So I do think timing is relevant here. Again, and it's not just that the defense waited so long, it's that we now have a very substantial record on which the court can deny this motion based on everything that's been put in front of the state and the court. In terms of the mitigation investigation, Your Honor, we believed but did not have confirmation that the defense had a mitigation specialist until the reply brief on this motion alluded to an affidavit that mitigation specialist submitted. So I don't know what that says. I don't know what the mitigation specialist has said, but the fact that there is a mitigation specialist, apart from the 3 attorneys and 2 investigators that are part of the defense team, that person has one role, as I understand it, which is to prepare for the penalty phase if we get there. And that person, that specialist, has still time to continue doing whatever work they told the court they need to do. Your Honor, again, I would try to get back to the record and ask the court to look at the objective record when evaluating this motion. 55 mitigation witnesses, over 130 exhibits, a very robust team on the defense side, which includes their retained experts. Ms. Taylor, and in the briefing, really honed in on this idea of a social life history for the defendant. I don't know if the court has read the expert reports of the defendant's forensic psychiatrist and then the licensed psychologist. I won't discuss the details in open court, but our position is that both of those specialists, well-trained, very experienced specialists, conducted significant, fulsome life history investigations. They weren't just looking at bare records. They were talking to people from the defendant's past, from his present, his family, and developed parallel life histories. And in their reports, as I read them, no red flags that needed further investigation were noted. Nothing about those reports appeared to be incomplete. And the experts didn't say we are unable to reach the conclusions we need to reach for lack of investigation. So I think that is sort of proof in the pudding. We have a life history for the defendant. The defense has amassed significant materials. And I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuance. And to the extent there are ongoing discovery from the state that Ms. Taylor alluded to, I can represent that most of what was just turned over was our investigators speaking with witnesses that the defense has disclosed. So that's the nature of that discovery, is us responding to discovery from the defense. And that will continue, of course, to occur as we lead up to trial and witnesses make statements that we need to disclose to the defense. So with that, Your Honor, I would again rest on the case law holding that a scorched the earth investigation is not what's required. And on the record before the court should exercise its discretion to deny the motion. If the court has any questions, I'm happy to answer those. Otherwise, we would submit on the record before the court.
Thank you.
Thank you.
Ugh. The microphones work,
Can you
Chad.
reply?
The microphones work.
Thank you. I would start with noting that if the new discovery is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but they are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refuse to speak with us have to do with records, medical records of Brian Kohberger, past treatment records of Brian Kohberger. Those are important things that the gravity of what they have to say can't be known to our experts until we have the opportunity to fully understand those things. And we continue to work on access to witnesses and access to additional information. Your Honor, I want to touch on just a couple of points. One, when the court considers a continuance and considers whether Brian Kohberger's rights are violated, his right to a fair trial, his right to confront witnesses and evidence against him, his right to present a full defense, and his right to effective assistance of counsel are implicated and laid out in our motion to continue. The ABA guidelines require us to do a full investigation. It's not going scorched earth to understand Brian Kohberger's full life history. These are things that are required. And we've done everything that we can. We have had a mitigation expert on the case. This is 2.5 years into a case, and the average for capital cases is 3.5 years.
In federal court,
In federal court.
which moves at a snail's pace in its best day in regular cases.
He does
I'm
not
not
want
a
to slow this
practitioner in
down.
federal court, so I don't have any basis to talk to the court about that. But what I can tell you is that a capital case where we have a client and we need to investigate both the merits phase and a penalty phase at the same time takes time. In any case, it takes time to do that. In this case, with the high-profile nature and having people decline to talk to us presents a whole set of challenges that we have to find a way to work through. As the court knows, a lot of mitigation information is very sensitive information. It takes some time to be able to get people to talk about things. Realities exist too. Not all of the family members are in the same place. So there's travel that's required. All of those things take time to do in a case like this. 2.5 years is excessively fast to put all of that together. There was no delay in having a mitigation expert on board. There was no delay in getting investigators to work on the case, and as soon as issues became apparent, Mr. Kohberger's team did not delay in getting experts to help us understand specific areas of the case. Looking over the entire record, the court can see that the defense team has been diligent about discovery, about motion practice, about litigating issues in the case. There just still is a lot left to do. There is still a lot left that is not known. And Mr. Kohberger has a right to go to trial with prepared counsel that have conducted a full investigation in both phases of the case. When you have a certain amount of information and there's this other stuff that's out there, that's a red flag, that's real, that you need to investigate, your experts can only do what's here, what's been investigated, what's been produced for them to assess. This whole other area, that land between the red flags and the investigation, that's an unknown area. That's where there's ineffective assistance of counsel. That's where there's not a fair trial. That's where there's not an individualized sentencing proceeding. And it's that area that requires a continuance in this case.
Oh boy, I think that slow as snail commentary was pretty telling from the judge. Doesn't seem like he likes courts and proceedings to move slowly.
All right,
Which
I'll
would
take the
suggest
matter
what?
under advisement and get an opinion out in short order. In the meantime, I fully encourage everyone to continue as if the trial is going to take place when it is scheduled for. Again, I reserve the right to
Change my mind?
write the decision that I come to, but as of now, I would tell you that it's likely you're going to trial on the date indicated.
I believe that's August 11th. We'll have to double check.
All right. Is there any other matters that we need to take up in the public session before we break to go to the private session?
Nothing further in the public session, Your Honor.
No, Your Honor, I don't believe so.
All right. We'll take a 10-minute break while the bailiffs clear the courtroom and we set up for the private session.
Yeah, so they didn't stream this, so this stream never came back. He just said it was a private session. They're probably discussing stuff that's under seal, you guys, so that would be why. And yes, it is August 11th is the date that they're supposed to move forward with trial. But did you catch that the way... Oh, opening statements are scheduled for August 11th, so not even jury selection. And jury selection's a lot of work, too, for the attorneys on both sides, especially in a high-profile case. So, yeah, August 11th, not just the start of trial, but opening statements. But did you hear the judge? Let's run that back, and then we can get over and look at some, I heard maybe juror interviews and what else? He didn't want to say, I reserve the right to change my mind, as if I've already made up my mind.
Tell you that it's likely you're going to trial on the date. Come to write the decision that it's going to take. Fully encourage everyone to continue as if the trial is going to take place when it is scheduled for. Again, I reserve the right to write the decision that I come to, but as of now, I would tell you that it's likely you're going to trial on the date indicated.
He tried to hold that facial expression together. That's my reading of it. He was about to say, I reserve the right to change my mind, but right now we're moving forward with August 11th and whatever jury selection days they predict it will take before August 11th. Oh, goodness. Let me refresh let's try Law and Crime over for Karen Reed. Oh my God, they're still going. It's very loud. We'll rewind a little bit and look at, I mean, that was nice and short. I'm breezing through. I just want to see if there's like any interviews on screen with Law and Crime. Okay, I see the interviews. So we'll go right to the interviews. We'll get the street view going. This is a little bit behind the live feed. Start it half muted and I'll crescendo it up for you guys. all the pink. People are not going to love that on the anti-free Karen Reed side.
No, the case cannot be reopened. This case is over. No, I mean, what is the larger issue? What does this say? This is what I say about justice. I'm going to leave it. I'm going to leave it to Karen and her dad. Her dad has a comment. Let her dad make the comment. Mr. RP, what does this say?
Ooh.
I want to acknowledge the strength of our daughter Karen, the support of the entire Reed extended family. I want to acknowledge the greatest team of attorneys. Our first one that we follow is David Galletti. We added Alan Jackson and Liza Little. Bob Alessi, you know about. All right.
Bob Alessi, you know about.
Team, but we needed them all to defeat this. We thank everybody for their support from our heart. We love you all of the content providers who help spread the word. Thank you so much. God bless you all. Should the investigation be
When you started your motion when your verdict was announced, what went through your mind?
Tremendous thanks to Almighty God, Jesus Christ, and the Reed. Thank you for our great family.
What do you think the difference is between this trial and the last one?
Another year of information circulating in the public, and people are aware of what's happened.
I gotta go. What's the message? I got you, sir. I'm right behind you. I got you. Let's go right to you.
Rich News says if I were her, I'd move out of Massachusetts. I'd get my car back and drive around with that busted tail light. Just as a finger in the air. Wait, like tomorrow they'll probably estimate the numbers of people that were here for this moment.
Open the road.
I'm not trying to be a horrible person, but can you imagine if trying to cut through that turn, they nudge something with the back tail light right there? Oh my goodness.
Got it.
Agree tape is. Let's find out what they've got going on. Like the departments seem a little funky bunch. And I want to say, I don't want to hear any criticism of what Karen said on the microphone about she's fought the hardest for justice for John O'Keefe from people who have not criticized Canton PD for not going to the funeral of John O'Keefe while they're on the stand saying that they were on good terms with him. Right? You can't have the double standard going on. Turtle Boy things. Guys, I think, I feel you, Sapphire Rich News. Have a good one. As I say, I think there are so many people live doing Karen Read. I'm looking at where to go, because I'm going to continue watching. I'm going to continue watching chat side. Turtle Boy is live. I know that's a major channel, a major journalist that has propelled the public awareness of this trial. Melanie Little's, everybody is live. Everybody is live. Let's see. Yes, Cash Money Cass. Did you hear? I'm assuming you heard Bev's like, all right, let's do sentencing. You're lying, factual lie. John DePetro? The one that was yelling at Turtle Boy? Okay, guys, we're gonna look. Let's pause this. Factual lie, thank you. So, guys, you guys know that there's the acronyms. There's Free Karen Read and there's Anti-Free Karen Read, right? There's been these factions. X has been one of the craziest places to see it. John DePetro, who's guested on a bunch of shows, was recently he wasn't named in the New York Post article, but he was, like, behind yelling at Turtle Boy. Turtle Boy was standing on his phone and just, like, heckling Turtle Boy. This is crazy if true. So, Dr. Turtle Boy, you're going to love this. John DePetro show literally hit someone's car in the parking lot and left. Here is the note. Older woman in the parking lot trying to figure out what to do. Backed into your taillight, please contact me. John DePetro. John at DePetro, maybe .com. I don't know what this little thing is. Oh, or www.depetro.com. So anyone could have written this note, but apparently there's let's see if we can get a video. What? Alright, so as of right, let's see. Oh my god, this is his post! Chat! On a serious note, I could not locate a business card. Be like that. So I put contact information on a note under the windshield. The owner can contact me at my website. So, fair enough. Fair enough. What are the odds? What is it? Serendipity is the word for something like this? Or is this a type of situation where, like, has he said anything like, see, a taillight can, well, it would go against his argument. Because Anti-Free Karen Read was arguing that, you know, Karen Read bumping into, like, backing her car out and bumping into John's car wouldn't have caused a crack in the taillight. Is the proof in the pudding with John DePetro's own little bumper? Okay, there's a lot here. How long ago was that? There was no collision when I was backing up. It was not broken. It looked cracked. Is he being funny? Oh, yeah, he's being funny because the next thing he says he's retaining Bob Alessi. So he's trying to turn it into a softer moment there. But yeah, like, serendipity right then and there. Because this is amazing. They want the overview coverage. Like, show anybody who's not there in person how many people showed up for this verdict. Largely wearing pink. Yeah, this is crazy. So, let's go back to this aerial view, watching them drive away. Big shout out to FFS. They all headed for drinks at McCaffrey's bar. No. Would they? Are they gonna get other people for OUIs? Oh, they just shouted out Jess Machado too. She's done a lot of coverage on this case. So, not guilty on everything except OUI with a blood alcohol level of 0.08. They're like in the other lane. Who's driving? Who got in the driver's seat? Oh my goodness. Oh, and so Crystal says, my grandson backed up our side-by-side and cracked the taillight on the Tahoe. I mean, if you're sitting on the jury, you have that real-life experience. You're going to be like, the car bumped into the other car. Could have cracked the taillight because I've seen it happen. So... But the first trial, the prosecution didn't even want to acknowledge that the car moved. They were arguing that it didn't move. Kiss and Pink, good to see you. I'm really waiting for Hank's response. Shout out a little bit to Hank for not pushing for anything egregious with sentencing. Just the 1-year standard probation and 24D program. 24D program might be like you have to go take a course on driving safety and the impacts. Let's see what it is. They zoom in. So this is an overview, right? So it could be incorrect. But Massachusetts 24D program offers first-time OUI offenders an alternative to traditional penalties, focusing on education and rehabilitation rather than incarceration. So there you go. She probably has to go to like a speaking seminar and, you know, learn what the impacts could be when you're driving drunk and don't make it home. So yeah, it's OUI, DUI, it's operating a motor vehicle under the influence. There's different statutes in Massachusetts and in other places for if it was like a boat instead of a like motor vehicle on a highway. Yeah, is this OJ's chase? Hey Cooper, that's the thing. I don't know if I think anybody actually killed him. I think the most reasonable thing is he fell, he was drunk, he could have been walking into a garage that had a down step, and he could have just tripped and fell and hit his head, and maybe there were marks on his arm, maybe the dog ran over to him at that point. I think the most reasonable thing, not the definitive answer, is it could have been a tragic accident. If someone actually killed him, it doesn't seem like they did a very good investigation into it. They tunnel visioned to Karen Reed, and they said that the vehicle was the murder weapon, and then I think the more compelling evidence and testimony shows his injuries and the damage to the vehicle weren't consistent with that theory. So yeah, it is sad. And, you know, I don't really know how I feel about, like, the family staring at the jury, the way the courtroom's positioned. I think that's a bit prejudicial, but at the same time, it's rough for the family members. It's rough for Karen and Karen's family. It's rough for the attorneys. I mean, what a beautiful thing that they continued pro bono when they had to do this again.
It opened a lot of people's eyes, too.
What do you think they're playing in the car? Do you think they're listening to the music? It's like a festival. It's like a, you know, like when they do the tents and they have vendors set up and everybody comes out for like the spring town fest.
Any words on camera?
And it's Wednesday. They're on their way to Club Class Day tonight.
Oh, long crime? Sure. Okay, sure.
Give me one moment.
Let me fix my hat.
What are your reactions to today's verdict?
I think that it was the right verdict. Definitely way too much reasonable doubt. And I'm just happy that justice was served today and Karen can be free.
How does this experience change your view of the justice system?
I already had my own run-ins with the justice system in Worcester. I knew that they were corrupt, and this just slammed it home for me.
What message would you like to send to others that might be going through a similar situation?
Stay strong and fight. Don't give up. That's right. Don't give up.
Thank you so much.
Justice prevails.
Thank you so much.
You want to ride? I give you a ride.
Hey! Thank you for coming, Burkhart. It's all that matters. Oh my God. I'm sweating.
they get any more? Oh, they got one here. Let's see what people think.
No, thank you.
Oh, no?
I'm fine.
Oh, if you want. Okay.
Yeah, free Karen Reed. I'm so happy about the verdict.
Okay.
It's great. Yep.
How has this experience changed your view of the justice system?
I have no faith in the justice system at all, unfortunately. It's not a good way to be, but it's how it has to be.
What kind of like key piece of evidence do you think was like important to his testimony?
I'm gonna say it was the cops in the investigation that did it for me. I feel like they planted evidence. I feel like they did things that broke tail lights. I mean, we all know. Come on, I don't have to go through everything, right?
Is there anything else you'd like to add?
Yes, free Karen Reed. We love you, Karen.
Thank you so much.
I will.
So yesterday, Wendy Murphy, used to be on shows giving her expert opinion on legal issues like decades ago. It seems like maybe, this is just my opinion, but it seems like what she was once known for, maybe she's not that same person anymore. But there was a talking point largely from the anti-Karen Reed crowd yesterday that was, we're watching a white woman get away with something criminal. And I have a lot of thoughts on that because while I do think that, your racial makeup can impact how people investigate you and how everything proceeds through the criminal justice system, on one hand, I don't think that applies here for Karen Reed, specifically to this situation. On the other, there was just a sentiment that people get treated poorly because of the color of their skin, so let's treat this other person worse too. Let's bring everything down a level. And I'm so adamantly opposed to that. If we think that there's an issue, we should want better procedures, better investigations, better evidence presented at trial, prosecutors that actually look for justice rather than just to get a conviction on the scorecard. We should want better processes, a better criminal justice system, rather than dragging down the level of our standards just because something has been unfair. I think it's been a really beautiful thing that perhaps because this was a white woman being accused, it got so much attention nationally that just like we had this woman say who just did this interview, she doesn't trust the system. This trial is exposing a lot of the unfairness. And for what it's worth, if you feel like she got the better end of the stick because she's a white woman, necessarily you should be thinking about how it can be so much worse for other people that can't fundraise. They don't have creators raising awareness, raising funds to pay for expert witnesses. They don't have a defense team that's willing to work pro bono. Like, just think about how much worse it is for other people. And I'm not saying that to say I think Karen Reed had a great experience here. What I'm saying is it just opens your eyes. It opens so many people's eyes. And it's nice. I think it's refreshing that Law and Crime is getting these opinions from people that are showing us that, hey, I realize that the system's crazy. So.
I will take it. All right.
Take care, Tay-Biz. Thank you again. Is anything specific happening? All right, looks like Law and Crime winds it down. They're just showing the crowd. There's Turtle Boy. We'll see if he says anything.
Oh, I'm excited.
Get a bunch. Got it? Thanks so much, man.
Congratulations, Aiden.
Can I just shake his hand first?
Yes, absolutely. Oh, of course. Thank you, absolutely.
That's what happened to Ava.
They're shooting photos.
I meant shake hands. I meant shake.
Congratulations.
All right, so let's wind this down. They're just doing handshakes and stuff. So you guys have pretty much heard my opinion on, I'm grateful for viral cases like this. I was grateful that YSL got national attention, global attention even. I think the reactions, it just puts it in the spotlight how investigations, procedures, all of these things can go wrong in so many ways. And if there isn't a spotlight on it, who's going to keep it in check? If we don't have star defense attorneys or great public defenders that don't have the time to put together a case, who's the block? Who's the obstacle to injustice? So I think it's great that this isn't going to end up in appeals court. I mean, she could appeal the OUI. Her body language, it doesn't seem like she's disgruntled about the OUI and the probation. By the time she were to appeal the OUI, I feel like her probation would run up. So that's a personal decision for her to make. We'll round this out. So Angel from Heaven, the YSL guys never really addressed the public, or am I wrong? Do you mean the attorneys? Because the attorneys have done a lot of interviews. Brian Steele in particular didn't. But I think he had a statement or two, like a one-liner that was around the time of the... especially when the verdict came down. He spoke after the plea for Jeffrey Williams. But I do think Brian Steele, there was like a statement or two, short and sweet, when the verdict was dropped, that AJC had caught. And then Keith Adams has also given statements. But the attorneys were all doing a bunch of interviews, and then the defendants. So, well, Jeffrey Williams, Young Thug, kind of tried to speak, and they ran to file a motion against him. Oh, he's threatening Viverito. But Shannon Stillwell recently, last week, I think, was like, now people see the injustice. Diamante Kendrick, I think, even though Doug has been speaking, I think Diamante Kendrick has kind of been more low. And that's his choice. I mean, if I were any of them, I'd understand why they wouldn't want to speak, because the Fulton County District Attorney's Office looks like they're just waiting. They're just sitting there. You guys already know I'm going to put the bush on the screen. They're just sitting there looking for a reason to drag you back into court and say you did something wrong. So, Yak has been kind of quiet in that regard, but Doug has been speaking. I also believe Seti Nash, and I don't know if Cash Money Cass is in here or wants to divulge anything. You don't have to. But they did get together and do some type of filming, waiting for that to drop, where it looks like Yak was present. So maybe something like that is going to be a way for Yak to comment a bit more intently on what he thinks of the whole process, right? And of course, when I see that, I'll make sure I share it in a community post and on X. So, oh, Yak's been doing interviews. Did he? Hey, wait, he did. That was a longer interview too, because Thugger Daily pulled a bunch of clips from that. You were right. You're right. That was really recent. Right, and he spoke about Gunna and... Go to Thugger Daily. That way I can link you guys to it. Okay, Danza and No Jumper. Okay, so thank you, Factual. I dropped a link here to one of the Yak interviews. Yeah, Bama Law, finally a case other than Reed, yet you must be either earlier in the stream or you just joined. It's couched in between Karen Reed verdict and Karen Reed reactions. But yeah, I feel you. But that's over now. That is over now. Yeah, I don't see when I search. I don't know what Duggar Daily keyworded the interview as. I don't see it coming up. I searched yak and it said no results, so I think Twitter's just being finicky. Yeah, Danza Project, or Danza Project, was the one that Duggar Daily was tweeting clips from. So there we go. Yeah, Bama Law, I've been listening and absorbing stuff about the Kohberger trial. I'm mostly interested. I don't like the idea that the media is talking about evidence that the defense might not even have had disclosed to them, right? I take issue with that. But as far as the facts of the case, you know, touch DNA is not compelling to me, but I'm open to hearing the totality of evidence the prosecution has against Brian Kohberger, and I haven't really formulated a strong opinion about the facts of the case. But I think there's a discrepancy between how certain the case has been presented in the media. Like definitive, beyond a doubt, they've got him red-handed. If that's not the case, I'm going to be really pissed off once again with the media and a prosecution team, right? Because you just never know. That type of coverage and that assurance in the coverage could impact the jury. Like, they're going to have to do a really serious job with voir dire to try to make sure jurors are being honest and being forthcoming if I already have an opinion on this case, and I don't think I'll change my mind. So, yeah, so guys, also in the description of this video, Andrea Burkhart and Dolly saying hella here. She's tagged as Excited Utterance. That's her channel name. They're both tagged in the description of this video. Tons of content, you know, other hearings, other motions, really a deep dive since December of 2022, following what's been going on. So tons of content on the Brian Kohberger case to check out from them. Get their links in the description. And Dolly says Hella is really firm on not guilty at the moment. To be fair, and I love Hella for this, but Hella is a huge advocate for a defendant's right to a fair trial and embraces, as anyone should, the beyond a reasonable doubt standard. So I'm not surprised that she's firm on not guilty at the moment. But she'll always give you reasons how she got there. And I might be the same way. Oh, we have a McAlbert statement. Hold on, let me open this on X. Shout out to Factual Eye. Just like an encyclopedia curating the interesting stuff that's going on. All right, so wait, what? Is this for real? From an undisclosed, this part's a joke though, right? So this reads, McAlbert's released a statement from an undisclosed location in Mexico. But it says, in a statement from Jennifer McCabe, Matthew McCabe, Chris Albert, Julie Albert, Colin Albert, Nicole Albert, Brian Albert, Carrie Roberts, and Kurt Roberts, they call the verdict a miscarriage of justice. Today our hearts are with John and the entire O'Keefe family. They have suffered through so much and deserved better from our justice system. While we may have more to say in the future, today we mourn with John's family and lament the cruel reality that this prosecution was infected by lies and conspiracy theories spread by Karen Reed, her defense team, and some in the media. Some. The result is a devastating miscarriage of justice. So I can picture them saying this. I think this is just a joke from Microdots. But there we go. Yeah, but okay, guys. So also, if you watch Hella, you know, Dolly Talk does a good... there's such a good balance when Dolly and Hella are both on panels together. There's such a good balance, and neither of them are afraid to, you know, hear the other side out if they disagree on something. So I always love it over there. Also, Dolly, you did the roundtable today. the courtroom round robin. Let's get this up here. I know if you guys aren't interested in following whatever trials are being streamed live right now that Karen Reed has ended, just know that Dolly's got you covered every day. Every day. Court roulette with Dolly. So there you go. There you go. Make sure you go follow Dolly. And Dolly, did you mention you were... I mean, I don't know if it's that serious because Megan Jackson just in less than 2 hours was convicted guilty. But were you requesting those records to see the text messages? Yeah, Factual Lie says John deserved a better investigation. 100%. As do so many people, right? So I hope people do not let the pressure off of Canton PD. Or BPD too. The troopers, Massachusetts State Troopers. Massachusetts State Troopers, that's such a mouthful. Chloe Albert's Revenge, the iconic chat member of the Karen Read trial, Chloe Albert's Revenge, says, head to the sidebar for some freedom fries. Heck yeah. Heck yeah. Those bars are probably going to make like such good money and have great business today. So happy to see you, Chloe. I'm sure you already know the verdict. I'm sure you're... Yeah, look. Oh, there we go. I think that's the sentiment. I think this is the right sentiment to wrap up on. Let me refresh and let's do a redirect. I'm going to send you guys to Karen Read stuff, so sorry to anyone who's tuckered out on Karen Read, but that's what we've got going right now. Today's the day of all days that case is going to be what's on people's radars. Yeah, so Turtle Boy's done. I see... We'll do Justice Served to see if they have boots on the ground. But guys, seriously, if you want to watch someone else, just search Karen Read. There's like 1 million channels live right now. So we'll go over to Justice Served. See you guys over there if you come hang out. If not, see you next time. See you next time, you guys. Appreciate you guys. Have a good one.